Are there any situations that you see a trend with that most commonly wind up not in the benefit of the learner for people in school districts to keep a lookout for?
No, I don't see any trend, but remember what happens when litigation is filed. There's a provision called the stay put provision, right? So the child's placement, programming, identification, evaluation, classification, everything has to remain in place. It has to stay in place. Unless, and there's a little provision in law that says, unless both parties agree in writing otherwise, which almost never happens. I've had it happen once in the last 17 years. But what happens is that child will always continue to get those services that the child needs while the litigation is happening. Now, are there times when the parents say, we don't want those services, and we're going to pull our child out and demand that the district give homebound instruction just because the parent doesn't want the child to be in the school, or because the parent distrusts or mistrusts the child's study team or the director of special services? I hear this all the time. That's when the child loses out on services, when the parent decides to use the litigation and emotionally get involved in the case and remove the child from the situation and not give the child services, and then demands the district does something that the district's not obligated to do. Again, all of this I'm telling you is straight from experience. I had a case 3 days ago where the mother removed the child from the program, just unilaterally removed the child and didn't unilaterally place the child at any other placement, just took the child out of school and put the child at home. My child's not going back to that school anymore because you're all a bunch of bleep, 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 bleep. And she said that at the meeting on Tuesday, repeatedly. But thank goodness the mother had an advocate there that could control her as much as possible. But the district said, you know what? We're not just going to allow this to happen. We'll provide the homebound instruction, even though they're technically not required to do that. My recommendation to them was get the child some services, because you don't want to harm the child because of poor decisions sometimes on behalf of a parent. And a lot of those decisions from that parent were coming straight out of emotion and anger towards one or two staff members, rightly or wrongly. That's where the situation was. So we provided the child with 10 hours of homebound instruction, and we worked around the parent's schedule. But again, that's not working out as well as the parent wants. And the district is being as flexible as possible to help the student. But again, now we're in litigation. The parents just filed an application for emergent relief yesterday, because they didn't like a psychiatric report that was done on behalf of the child that they consented to. So you're dealing with a lot of moving parts when you're trying to help students with special needs, especially when litigation is filed. But as far as trends that I've seen that are trying to not, have the learner, as you say,
nothing consistent.
Consistently benefit, I don't see that happening very often.